Hi everyone, this is Emily, staff attorney at the Family Center, which is a nonprofit agency located in Brooklyn, New York. Today we are going to talk about what to expect when you first appear in housing court after you have been served with a non-payment or a holdover petition. Remember that a non-payment petition is about the fact that you may owe some rent to your landlord, you have some rent arrears. A holdover petition is served when you don't have permission to stay in your apartment because your lease has expired or you have violated one of the rules of your lease. Also note that just because you have been served with these papers doesn't mean that you are actually in the wrong. Sometimes landlords serve these papers under the impression or under the belief that there is a problem with your tenancy, but that's not always true. Even if it's not true, you should make sure that you show up to court either on the day listed in your petition or on the day that the court has told you when you go in to answer. We always recommend that you try to contact an attorney before you appear in housing court on your first day, and that's for your benefit and protection. If you aren't able to find an attorney to represent you, either a private attorney that you can hire or an attorney from a nonprofit free legal services organization, I wanted to offer some tips about what to expect on your first day in court. In most housing court cases, you'll show up in the morning. I recommend that you get to the courthouse at about 9 a.m. for a 9:30 call because there can often be a long line outside to get in and pass through security. After you enter the courthouse, you go up to the courtroom listed on your papers. Sometimes it's called a part. For instance, you could be in part 52 or part 8, and that is the name of the room, the number of the room where you're going to go. In every housing court case, there will be a calendar outside of the courtroom, and on the calendar, you'll find your name, your landlord's name, and the index number for the case. When you check in to tell the court officer that you have shown up for court, you don't need to give them your name or your case number. Actually, you want to give them the highlighted number that is next to your name. It will be a number from 1 to 20 or 1 to 50, depending on how many cases are on the calendar that day. So the first thing you want to do is find the number of your case, like I said, 1 to 20, 1 to 50, not your index number, and tell the court officer inside the courtroom that you're there. If you have an attorney, you should wait for your attorney to show up, and you don't have to talk to anybody until your attorney gets there. If you don't have an attorney, what you do next is wait for the landlord's attorney to find you or to call your name. A lot of times, landlord's attorneys will ask to speak with you outside in the hall and try to negotiate a deal with you. This can be uncomfortable sometimes because you are there by yourself, you don't really know what to expect, you don't know what your rights are. So the most important tip I can give you is to not sign anything that you don't understand. If you feel pressured, if you feel confused, if you feel like your point has not been heard, make sure not to sign anything because you will most likely be obligated to fulfill the provisions of what you have signed. Even if the landlord's attorney is trying to get you to sign something, even if you think you understand, my recommendation is that you speak with a court attorney who is an assistant to the judge or to the judge, him or herself, to make sure that everything that is in the stipulation, in the agreement that you're signing, is something that you understand and that you can actually fulfill. If you are wanting to find an attorney to represent you, you can always ask for an adjournment. An adjournment is when you ask the court to give you a return date, another date to come back to court so that you have time to find an attorney. Again, you can always ask the court to give you more time to find a lawyer. You don't have to talk to the landlord's attorney if you feel uncomfortable or you would prefer to work on the case with the judge or the judge's assistant. And most importantly, make sure you don't sign anything that you don't understand. It's much easier to resolve a problem right from the beginning than to have a kind of medium solution and then have to go back and fix that after it doesn't work out. Thank you.